All the rest of these gurus on TikTok will tell you that shit. But watch what I'm gonna tell you. Where I'm reading from is 15 U.S. Code 6802, obligations with respect to disclosures of personal information. Section I'm reading from is B1. In this section, it tells you a financial institution may not disclose anything to a third party unless they do something. The first something they must do is give you a disclosure prior to them reporting information to their non-affiliated third party. This section states that the financial institution must let you know that you have the right to opt out of that information reporting to the non-affiliated third party. This section here states they must give you an explanation on how to use that non-disclosure right or non-disclosure option. So you have the choice. You can send a debt validation letter off and let them waste your time, or you can write a letter demanding that they remove from your report because they didn't let you know you had the right to opt out. The choice is yours.
For themselves without using an attorney. And there are many reasons for that. Attorneys, by their very nature, are dishonest individuals. They're there for mainly, at least when it comes to criminal law, your defense attorney's goal is one thing and one thing only: to ensure that you do not have appealable error. Now, you understand that. It is not to defend you. It is not to get you off of the charges. It is to ensure that once you've been convicted, you don't have any appealable error to go forward with.
Can you explain what that means exactly, appealable error?
Appealable error is something that you can take to an appellate court to say, hey, my conviction should be overturned because, and then you've got legal facts that justify the overturning of the case against you, or at least changing the punishment or something that would alter the way the outcome of the case was. Here we're talking about an attorney whose sole job is to ensure that you have no way to make that claim. In other words, he's actually working for the other side. And the way he does this most of the time is he starts by waiving your most fundamental rights right out of the gate. For instance, are you aware that when you go into a court and you enter a plea in a case like this, especially in a case where it's considered criminal like it is here, when you go in and enter a plea, you have waived no less than 3 very important fundamental due process rights. You have waived the right to notice. You have waived the right to challenge in personam jurisdiction, which is jurisdiction over your person. And you have waived the right to challenge the form and substance of the charging instrument and the indictment or information. The complaint, the indictment or information. So just by entering that plea, which they attempt to coerce you to do through threats of issuing a warrant if you don't do it and things of that nature, they're trying to get you to waive those rights so that you don't have appealable error on their failure to follow procedure.
So what are you supposed to do in that circumstance?
Well, you challenge the court. First off, if they haven't filed the proper documentation, the court lacks jurisdiction to be doing anything, including taking and entering a plea on the record. But they do it all the time because people don't know to challenge them on it.
That's really fascinating.
A lot of this system gets away by fraudulent means. They do what they do by not fully disclosing the consequences of your action.
Why would lawyers be working, I guess, essentially, as you said, for the other side to get you to enter this plea to waive those rights? What's the benefit to the lawyer there?
More money. It's a very simple process. Most criminal defense attorneys that are doing public defender work get paid a flat fee for what they do. Let's say it's $350. If he has to spend 20 hours on your case and his normal billing rate is $250 an hour, he's losing money by fighting for you, isn't he?
Yeah.
Okay. So if all he can do is walk into that court and say, we plead guilty or we plead not guilty, please set it for a jury trial and walk out again, he spent 2 whole minutes on your case and he's still getting $350. So right now he's 58 minutes and another $100 ahead by that type of defense work.
Afternoon. Happy Thursday, everybody. Hope you're all doing good. Hey, while we're waiting on the UCC stuff to come back and find out how much trouble I'm in, Somebody asked me to do some research, specifically 1099-A and how to buy a house. Been looking at it. Don't know if it's true or not yet, but we're going to find out a few things today. So a couple minutes of your time and you might learn something. I don't know. Have fun. All right, 1099-A to buy a house. You need three things for this to happen. You understand that part. The Treasury Department, good old IRS, and a trustee, okay, because they have to process this for you. All right, so this begins by filling out your 1099-A. That form you can order from the IRS, right? Or you can fill it out electronically, 1099aonline.com. Excuse me. In that form, you need a lender. That's the Treasury Department. Put in their EIN. You can get that online as well. The borrower is going to be you. You need the date you're filling it out, the date you want to acquire the property. How much do you need? This number is determined by a few things down here, so we'll get back to it, okay? You see, I put 4 million in there. You'll understand in a minute. Fair market value. This is whatever number you give it. They have no way of knowing, and it's whatever you say it's worth. I put in 4 million. A description of the property, a physical description, plat XYZ in this city, in this county, in this state. Okay? Once all that's done and you pay a $3 and change filing fee, you get an account number. All right? About 2 to 3 days later, I'm being told, that zips on over, right? And the Treasury either okays it or they don't. And I'm being told again that the okay is, or the denial is based off of how much is in your CSQ trust. Okay, so that would be based off of your age if all this is true. All right, so you send that request over, the Treasury okays it, sends it back to you. Bam, you're good. Take that account number and you forward it over to your trustee, whoever you decide to do business with. This guy's important, and we'll get back to him. They fill out a 1099 OID and they send that back over to the Treasury. And it says, hey, we're the trustee for this beneficiary. He or she is trying to live their life better. And we need you to release these funds for them because it's theirs. We're acting in their best interest. Treasury says, everything looks good. It's all filled out right. Is that about the government? As long as the paperwork's right. Treasury then says, okay, release it. So you're looking at 45 to 60 days total is what I'm being told, depending on how fast the Treasury is moving, if they're backed up or whatever. From right here. When you send that 1099-A over, you're looking at about 45 to 60 days. Now, this is not cash, guys. This stuff ends up in a trustee's account that they're managing for you, right? On your behalf, so you can live a better life. They close with the title company on your house. Boom, you've got a deed, move in. You better take care of that right after that, land patent. Pay your taxes for the year, homeowner's insurance, maintenance, repairs, furniture, linens, their 5% fee for processing the transaction for you. All of it is included in this number right here. That's why I have 4 million here, because I don't need 4 million for the house. I need 3.2 million for it. The other 800K is going to sit right here in this trustee's account. Anytime I need to pay a bill, I'm going to send the bill to him, stamped with my beneficiary signature on the back of it, and my trustee is going to forward it on and pay it out of the money that's left in this account. So you say, well, all that's fine and dandy, Joe, but what the fuck? Who's going to do that? Well, I had the same question. It took me about a week and a half, but I found him. Uh-oh. Well, at least I think I found him. The research I showed that he has been doing it for about the past 2 years. His primary goal, he told me, was to free anyone with a Social Security number. All they had to do was come to him. So we're going to find out. Like I said, we're right here in this process with me. I just filed this last night, and I did put it in for that, for a house that we found for that. I want you to hang out, see how it goes. You know, if you've done it, if you haven't done it, if it was successful, if it failed, if somebody scammed you, if you think you got took, let's talk about it. I believe that the only way we're going to be free is to share the information that we find. Don't charge somebody for it. share it. All right, guys, we'll be back tomorrow to talk about something else. Think about it. Let me know what you think.
But we basically replied to his, send us a letter in writing as to, your legal basis. So we wrote back, well, thank you for reviewing our documents.
Right. And I think I told you, don't do legal basis. You could attach a legal.
Yes, that's right. We put, we apologize for any confusion. As the aggrieved, our lawful basis is that we require the use of this venue as a court of record to seat a jury in which we move our claim before. So
there you go.
Determine and render a verdict as to who has the lawful right to tender or administrate our property.
That's a good letter. Did you send that to me? See, now you're starting to get it.
We, the aggrieved, or the defendants, and immediately, as soon as he received this, within an hour, he opened up a court of record for us. The court stenographer and the court clerk, and he basically brought us right in. He had the habeas and he had the claim. And
do you know why?
He basically said...
know why? They opened it up. Do you know why they opened it up?
Why is that?
Because you're considered like a king or a queen. You're considered a sovereign, and when you want to convene court, it's open to you 24/7. Like, if you ever watch an old movie, like a Queen of England, Elizabeth II or whatever, Elizabeth I, and all of a sudden she wakes up at 3 o'clock in the morning and she says, round up my court, get my court. It's like, Queen, it's 3 o'clock in the morning. Well, I'm convening court. Get everybody into my court now.
Right.
And that's right. You do. And the judge realizes, like, holy crap, we got a queen or a king present before the court. We got to convene. Yesterday.
That was kind of our feeling about it. We're like, oh, finally, they got the memo. Everyone started to change their attitude completely. There was no more mocking, and there was no more, no, we won't take this paperwork. It was, yes, right away, sir. Yes, right away, ma'am. Please just be one moment, and we'll be right back with your original copies. And, it was a complete, utter turnaround, complete 180 from Wednesday when we tried the same thing.
What I'm saying to you, folks, So what I'm saying to you folks is this start making a little bit of sense. Hang on a second. So what I'm saying to you folks, start to understand that when you're in a common law nation, these people in the black robes do understand their role.
Yes.
Yeah. See, this is what I'm trying to tell you folks. These judges aren't stupid. The court clerk isn't stupid. The clerks of the courts might be, a little bit in a shadow still. They might not know the whole picture. If you go to the chief judge, he knows what court is. He knows exactly what's going on.
Right.
He's not stupid by a long shot, but like I said, he's trying to throw that little hook in there to keep you one side of being totally what you folks would call free of their control. Right. So they're trying to keep one foot in the door. They're trying to do it, and he's got to do it on their side. He's trying to help his society, his legal society, his government. He's trying to make sure that you're not going to both break away. It's like, Canada's like considered not like, well, maybe it is now, but like England or the UK has dozens of like satellite countries that aren't fully sovereign. There's like 120 countries like still under the control of England or the UK. But they go keep that one foot in the door, and they don't truly let those countries break away. You see what I'm saying?
Yeah.
That's what they're trying to do to you. They're trying to let you break away to a point, but they still want to make sure they maintain some sort of control and authority over you by stylizing your order in a certain manner.
Another control mechanism.
That's all I'm trying to say. They're smart. This guy is smart. Like I said, that's why I got asked to be a judge plenty of times, because I know how to throw that little hook in there to keep you under my control.
Wow.
Yeah, it's that simple. It's very simple. This is very simple how they master the mastery of the words. And you'd think that they're being kind and, but they're trying to keep one foot in the door, because if this stuff breaks loose, what you're going to do, like I try to say to you, what I do, if this stuff breaks loose, it's going to be unbelievable what could happen.
Okay, Liz, can you hear me? I can see you on the screen there.
Yes, can you hear me?
Yes, I can hear you, so that's fine.
Yep,
So
I'm
you're
also on
representing
camera.
yourself today?
Yes, I am.
Oh, sorry. Oh, yeah, thank you. I'll just read the charge out quickly for you. So it's at Melbourne on the 13th of September 2020. Did fail to comply with the direction given to that person. That direction being to stay at home unless for essential shopping, work, exercise or caregiving purposes having been given by the person exercising the power granted by the Chief Health Officer under Section 199 of the Public Health and Wellbeing Act. So in relation to that charge today, are you intending to plead guilty or not guilty?
So, Your Honour, I am the living woman.
Yes.
I'm the beneficiary of the Open Trust. I do not consent to contract or joinder, and I waive the benefits on offer.
Okay, so I'll take that statement to mean that you're intending to plead not guilty today. So thank you for that. I think, Mr. Prosecutor, in this circumstance, contest mentioned? Yes, Your Honour. Yes. Your Honour, I've been given a copy of the to the court. Yes. I haven't had any correspondence. I can't see that there's been any correspondence. So no objection to the objection. Yes, thank you. I think it's suitable. I'll get a date in case contest mentioned that. So, so the next, I'll give you a next date now. This will be the contest mentioned date, okay? So there's various steps that the matter has to go through before it gets to a contested hearing. So I understand that's what you've been looking for eventually anyway, would be a contested hearing or some chance to address the court in relation to the charge. Today is only a mentioned court, so we're sort of triaging matters into basically matters that are going to be pleas of guilty or pleas of not guilty. So not guilty pleas need to go down a different pathway. So if you just hold on there for a second, we'll get a new court date.
So, Your Honour, are you administering my trust without my consent?
No, there's no administration of any trust at the moment, so we're just dealing with the matter under the Criminal Procedure Act. Okay, so that's 2009, an act in force in Victoria, and the next step will be a mention date under the Criminal Procedure Act under Section 55 of that act. So if you take it under Section 55 of the Criminal Procedure Act, that will be the next court date. Process of what's occurring.
I do not consent to contract or joinder, and I waive the benefits on offer.
Thank you, Ms. Your matter now is booked in for the next court steps to occur. The next court date is the 7th of December. Okay, so that'll be a contest mention back online in the Melbourne Magistrates Court. Okay, so that might take between 15 minutes and half an hour, depending on what's discussed on that day. But that mention date will give you a better chance to discuss your matter further. Okay, and the submissions you wish to make. Okay, so thank you for your time today in court, and you're now excused.
Thank you for your time, Your Honour.
Thank you. We'll just confirm, you're on the line there. You can see and hear us.
Yes, can you hear me?
Yes, I can. Thank you. There is an application to withdraw this matter. All right, thank you. On the prosecution application to have the charge withdrawn, the charge is now struck out. Thank you. The charge has now been struck out. You may be excused.
Thank you. Thank you, Your Honour.
Thank you.
Chapter 3 Dishonor of Negotiable Chapter 3 Dishonor of Negotiable Instruments 1. Introduction. A promissory note, bill of exchange, or check is said to be dishonored by non-payment when the maker of the note, acceptor of the bill, or drawer of the check makes default in payment upon being due. Required to pay the same. Point 1. It has been noted above that dishonor by non-acceptance could be only of a bill of exchange, but dishonor by non-payment could be of any negotiable instrument including a bill of exchange. When presentment for payment is made and the maker, acceptor, or drawee as the case may be makes default in making the payment, there is dishonor of the instrument. 1. Section 92. Dishonor is of two kinds, 1. Dishonor of a bill of exchange by non-acceptance. 2. Dishonor of a promissory note, bill of exchange, or check by non-payment. 2. Dishonor by non-acceptance. Since presentment for acceptance is required only of a bill of exchange, it is only the bill of exchange which could be dishonored by non-acceptance. Section 91 provides that the dishonor of a bill of exchange by non-acceptance may take place in any of the following ways. A. When a bill of exchange is presented for acceptance, and the drawee or the drawees makes default in acceptance. When there are several drawees, even if one of them makes a default in acceptance, the bill is deemed to be dishonored unless these several drawees are partners. Point 2. Ordinarily, when there are a number of drawees, all of them must accept the same, but when the drawees are partners, acceptance by one of them means acceptance by all. If the drawee does not accept within 48 hours of the presentment of the bill of him, the bill is deemed to be dishonored because the drawee is entitled to only 48 hours time exclusive of public holidays to consider whether he will accept or not. Point 3. B. Where presentment for acceptance is excused and the bill is not accepted. For example, if the drawee cannot, after a reasonable search, be found, the bill is dishonored. Point 4. C. Where drawee is incompetent to contract, the bill is treated to be dishonored. According to Section 26, a person capable of entering into a contract can accept a bill, and a person who is not competent to contract cannot make any acceptance. Since a person incompetent cannot contract to make any acceptance, therefore, when such a person is the drawee, the bill is deemed to be dishonored by non-acceptance. D. When the drawee makes a qualified acceptance, the holder may treat the bill of exchange having been dishonored. It is expected that the drawee will make an unqualified acceptance. If the drawee makes a qualified acceptance and the holder agrees to that, all those parties who do not consent to such an acceptance are discharged from their liability towards the holder. Point 5. It is, therefore, in the interest the holder that when there is a qualified acceptance by the drawee, he should consider the bill to be dishonored. Examples of qualified acceptance are accepting to pay a different sum, or to pay subject to fulfillment of condition, or to pay at a different place than stated by the drawer in the bill of exchange. 3. Dishonor by non-payment. A promissory note, bill of exchange, or check is said to be dishonored by non-payment when the maker of the note, acceptor of the bill, or drawee of the check makes default in payment upon being duly required to pay the same. Point 6. It has been noted above that dishonor by non-acceptance could be only of a bill of exchange, but dishonor by non-payment could be of any negotiable instrument, including a bill of exchange, when presentment for payment is made and the maker, acceptor, or drawee, the case may be, makes default in making the payment. There is dishonor of the instrument apart from that. Clearing the slate. Affidavit of foreign status. This affidavit of foreign status is a public notice to all interested parties concerning the affiant's birthrights and his status as an American inhabitant, as that status would apply with respect to the American states, the 50 independent states of the Union, and respect to the United States as follows. 1. The undersigned affiant was naturally born as a free, sovereign and affiant state of birth, which is one of the sovereign states of the Union of several states joined together comprising the Confederation known as the United States of America. 2. The affiant is, therefore, a non-resident alien individual residing in United States, which entity obtains its exclusive legislative authority and jurisdiction from Article 1, Section 8, Clause 17, and Article 4, Section 3, Clause 2 of the Constitution for the United States of America. 3. The affiant's parents were sovereigns also, born in sovereign states of the Union. 4. As the progeny of sovereign people, the affiant was born one of the sovereign people, a constituent member of the sovereignty synonymous with the people. Scott v. Sanford, 19-404. 5. The affiant is alien to a so-called 14th Amendment, United States citizen and non-resident to so-called I-4th. The presumption of innocence. Amendment state residency, and therefore, he is a non-resident alien with respect to both 6, as a sovereign whose citizenship originated in affiant state of birth, by birth, and who has remained intact in affiant state of birth. Since then, the affiant, also a foreigner alien with respect to the other 49 states of the Union, and with respect to the corporate United States 7, as a consequence of his birth, the affiant is an American inhabitant. 8. The affiant, to the best of his knowledge and belief, has not entered into any valid agreements of voluntary servitude. 9. The affiant is a non-resident alien with respect to the United States as that term is defined and used within the Internal Revenue Code, IRC, Title 26, United States Code, and Title 27, and the rules and regulations promulgated thereunder as follows. The Internal Revenue Code, Title 26, United States Code, and associated federal regulations clearly and thoroughly make provision for Americans born and living within one of the 5 sovereign states of America, to wit 26 CFR 1.8714 proof of residence of aliens of the federal zone. Rules of evidence. The following rules of evidence shall govern in determining whether or not an alien within the United States, incorporated, has acquired residence there for purposes of the income tax. Be non-residence presumed. An alien by reason of his alienage is presumed to be a non-resident alien. 10. The affiant was not born or naturalized in the United States. Consequently, he is not a citizen of the United States nor a United States citizen, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C., and or Title 27, and the rules and regulations promulgated thereunder, and therefore he is not subject to the limited, exclusive territorial or political jurisdiction and authority of the United States as defined. The United States is definitive and specific when it defines one of its citizens as follows. 26 CFR 1.11 Income tax on individuals. See who is a citizen. Every person born or naturalized in the United States and subject to its jurisdiction is a citizen. 11. The affiant is not a citizen of the United States nor a United States citizen living abroad, as those phrases are defined and used within the Internal Revenue Code, 26 U.S.C. and or Title 27, and the rules and regulations promulgated thereunder. 12. The affiant is not a resident alien residing within the geographical boundaries of the United States, as that phrase is defined and used within the Internal Revenue Code, 26 U.S.C. and or Title 27, and the rules and regulations promulgated thereunder. 13. The affiant is not a United States person, domestic corporation, estate trust, fiduciary, or partnership, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C., and or Title 27, and the rules and regulations promulgated thereunder. 14. The affiant is not an officer, employee, or elected official of the United States, or state, or of any political subdivision thereof, nor of the District of Columbia, nor of any agency or instrumentality of one or more of the foregoing, nor an officer of a United States corporation, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and or Title 27, and the rules and regulations promulgated thereunder. 15. The affiant receives no income with respect to employment from any sources within the territorial jurisdiction of the United States and does not have an office or other fixed place of business within the United States from which the affiant derives any income of wages as such, as those terms and phrases are defined and used within the Internal Revenue Code, 26 U.S.C., and or Title 27, and the rules and regulations promulgated thereunder. 16. The affiant has never engaged in the conduct of a rade or business within the United States, nor does the affiant receive any income or other remuneration effectively connected with the conduct of a trade or business within the United States, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and or Title 27, and the rules and regulations promulgated thereunder. 17. The affiant receives no income, wages, self-employment income, or other remuneration from sources within the United States, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and/or thereunder, Title 27, and the rules and regulations promulgated. 18. All remuneration paid to the affiant is for services rendered outside, without, the exclusive territorial, political, and legislative jurisdiction and authority of the United States. 19. The affiant has never had an office or place of business within the United States, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and/or Title 27, and the rules and regulation promulgated thereunder. 20. The affiant has never been a United States employee, nor employer, nor employee, which also includes, but is not limited to, an employee and/or employer for a United States household and/or agricultural activity, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and/or Title 27, and the rules and regulations promulgated thereunder. 21. The affiant has never been involved in any commerce within the territorial jurisdiction of the United States, which also includes, but is not limited to, alcohol, tobacco, and firearms, and Title 16, Subtitle D, any excises and privileged occupations, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and/or Title 27, and the rules and regulations promulgated thereunder. 22. The affiant has never been a United States withholding agent, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and/or Title 75. And the rules and regulations promulgated thereunder. 23. The affiant has no liability for any type, kind, or class of federal income tax in past years, and is entitled to a full and complete refund of any amounts withheld, because any liability asserted and amounts withheld were premised upon a mu, or mistake, or facts regarding the affiant status. 24. The affiant has never knowingly, intentionally, and voluntarily changed his citizenship status, nor has he ever knowingly, intentionally, and voluntarily elected to be treated as a resident of the United States. 25. The affiant, to best of his current knowledge, owes no tax of any type, class, or kind to the United States, as those terms are defined. Seven. IRS levies and liens. Written by Rico S. Giron, future sheriff of San Manuel County, New Mexico. http://ricoforsheriff.com. The Federal Reserve Bank, aka the IRS, is the biggest lie and scam in world history. IRS are the three most frightening and loathed letters in the English language. This deep-seated fear and loathing serves a very specific purpose. It serves to keep the people of America enslaved in submission to an illusion, a lie. It is an emotional and psychological chain around the neck of the American people. The IRS has a horrible reputation and has earned every bit of it. It has, by their own admissions, committed crimes against innocent citizens and continues to be the Gestapo of America today. They confiscate more homes, destroy more families, take more money, ruin more lives, and commit more crimes than all the street gangs combined. They are indeed vivid proof that the greatest threat we face as a nation is our own federal government. From The County Sheriff, America's Last Hope, by author Richard Mack. Here it is in a nutshell. The IRS is a private debt collection agency for the private banking system known as the Federal Reserve Bank. 107. Learn to play the game. The IRS is not a government agency. I repeat, the IRS is not a government agency. Never has been, never will be. The IRS, formerly the Bureau of Internal Revenue, BIR, situated in, and with authority only in, the Philippine Islands, Trust Fund Number 61, later moved into Puerto Rico, Trust Fund Number 62, as well. In the 1950s, with the stroke of the pen, the BIR was transformed into the current, notorious IRS and brought onto the 50 United States. This was done without any congressional authority whatsoever. There is no congressional authority for the IRS to exist and operate in the 50 states of the Union recorded anywhere in any law books. Again, keep in mind that the IRS is the private debt collection agency for the private banking system known as the Federal Reserve Banks. Due to the naive ignorance of the American people, most Americans do not realize that there are two Titles 26. Title 26, Internal Revenue Code, is the debt collection manual for the IRS. This manual has nothing to do with constitutional rights. The IRS does not collect an income tax. The IRS is simply collecting a user fee payable to the Federal Reserve Bank because we Americans are using this private credit system. The user fee had to be disguised as an income tax to fool the American people and keep them enslaved. Title 26, United States Code, is non-positive law, which means that no American citizen is subject to it. However, all U.S. citizens are subject to it. In order to understand U.S. citizen, you must go to 28 U.S.C. Section 3002, squared. Camericalo applied. Most American citizens have perhaps unknowingly, but voluntarily, surrendered their sovereignty in exchange toward the immunities and privileges of the 14th Amendment. There are literally hundreds of silent, unilateral contracts by which American citizens declare themselves to be U.S. citizens and thus subject to both Titles 26. By voluntarily becoming a U.S. citizen, every American citizen declares him herself to be an indentured servant, a slave to the non-federal Federal Reserve banking system with no constitutional rights whatsoever. So then, Title 26, USC is a private law that applies only to U.S. corporate citizens, who are all employees of the corporate entity identified at 28 U.S.C. Section 300215. ABC as the United States. 15 United States means A federal corporation, B an agency, department, commission, board, or other entity of the United States, or C an instrumentality of the United States. Consider this fact. When an IRS agent wants to seize property from a citizen in a county, they must first contact the sheriff of the county and request assistance in the seizure, because the IRS agent has no authority to seize any property at all. So the IRS agent bamboozles the sheriff into committing the crime for the IRS. When the sheriff seizes property from a citizen under the non-authority of the IRS agent, the sheriff has committed a second-degree felony, conversion of property. 10. 7. IRS levies and liens. Written by Rico S. Giron. A second-degree felony is incredibly serious. However, both the IRS agent and the sheriff, knowingly or unknowingly, count on the ignorance of the citizen who has no idea what their lawful rights are. Bear this point in mind. If the IRS agent has no authority to seize any property at all, then they cannot delegate or confer to the sheriff what they do not have. In addition, the sheriff has no idea that he has engaged in a serious crime. Here is where the maxim, ignorance of the law is no excuse for violating the law applies. Hence the maxim, the law leaves the wrongdoer where it finds him. We do not have an excuse based on the legal system. Both the IRS agent and the sheriff should be arrested and charged with conversion of property, a second-degree felony. Tyranny is defined as dominance through threat of punishment and violence, oppressive rule, abusive government, cruelty, and injustice. What better definition than this fits the abusive IRS? America is using a private credit system wherein the medium of exchange is the Federal Reserve notes that we call dollars. Hence, the so-called income tax is in reality nothing more than a disguised user fee that Americans must pay to the non-federal Federal Reserve Bank for using their private credit system. Research Title 12, USC. The legal definition of dollar is a gold or silver coin of a specific weight and with specific markings. Thus, a Federal Reserve note, FRN, is not and cannot ever be a future sheriff of San Manuel County, New Mexico. The IRS is not a government agency. I repeat, dollar. A note is not money. See Black's Law Dictionary. The Federal Reserve notes in use today are mere evidence of a debt. I repeat for emphasis, Federal Reserve notes are not dollars and can never be dollars. The Federal Reserve banking system is not a federal government agency. There aren't reserves, and there is no real money of account of the United States in existence and use today. The Federal Reserve banking system is a private cartel that has usurped the authority of the Congress to coin money. Federal Reserve notes are just as worthless or just as valuable as monopoly money used in the game Monopoly. If we go to the Constitution for the United States of America, Article 1, Section 8, we find that only Congress was given the authority to coin money, regulate the value thereof, and a foreign coin, and fix the standard, weights, and measures. This authority given to Congress by the Constitution for the United States of America was not to be delegated to any private corporation for that corporation's private gain. The authority to coin money was usurped by the unlawful enactment of the Federal Reserve Act of 1913. The Federal Reserve Act is a private law passed by only 4 congressmen after the congressional session had closed for the Christmas holiday in December of 1913. Congress can pass both private laws and public laws. Congress does not have to tell the American citizens which law is private and which law is public. We are simply led to believe that all laws are public. This is propaganda and brainwashing at its best. Starting from 1913, we Americans voluntarily submitted to this private law through our own ignorance. Once we submitted to this private contract law, we became voluntary slaves of the Federal Reserve System. This was a silent coup d'etat wherein the American people became the slaves of the Federal Reserve Bank. The killing blow, the coup de grace pronounced de grace, was delivered upon the American people by Franklin D. Roosevelt in 1933 by removing the gold standard from the American economy. Franklin Roosevelt assisted the FRB in heisting the gold supply from this country right out from under our noses. The Federal Reserve Bank is the single largest sting operation ever set in motion. FDR knew what he was doing. Since then, no American citizen has actually paid for anything. We have just exchanged worthless Federal Reserve notes for more worthless Federal Reserve notes. We lease our property from the state of your state. We lease our cars. We lease our houses. We own nothing. Since 1933, no American has owned their property in allodium. That is why the state of your state can take your property for just about any reason. That is eminent domain, failure to pay so-called property taxes, state income tax, etc. For anyone who has ever dealt with a debt collection agency, you know how nasty, mean, and dirty they can be. Now take that nastiness, that meanness and dirtiness, and